Bonjour tout le monde. Welcome everybody. I'm Roy Min. I'm an O'Brien Fellow of the Center for Human Rights and Legal Pluralism. Je veux juste faire une petite déclaration pour les peuples autochtones parce qu'on est dans le lieu des peuples autochtones et l'université McGill est sur un emplacement qui a longtemps servi de lieu de rencontre et d'échange sur les peuples autochtones, et y compris les nations, les Premières Nations. Nous reconnaissons et nous remercions les divers peuples autochtones dont les pas ont marqué ce territoire et sur lequel les peuples du monde entier se rencontrent maintenant. Et le centre est très reconnaissant pour cette activité. Merci.
Thank you, Raymond. My name is François Crépeau. I'm the director of the McGill Center for Human Rights and Legal Pluralism. It's an honor and a pleasure to welcome today Professor William Schabas to this faculty. It's an honor because of his distinguished career, his many books, articles, and prestigious awards. It's a pleasure for me personally because we've been colleagues and friends for over a quarter century, including a decade as, sorry, yeah, I could have softened that, including a decade as colleagues at UQAM here in Montreal, and we still have very fond memories of that time together. I would like to let you know that Bill will have other public activities at University of Montreal tomorrow and Saturday, and on Saturday evening there's, if I'm not mistaken, a conference at the McCord Museum at 5 for those who are interested. In the interest of time, I will not read the bios of the participants in the panel. You can have them in the program that was distributed. I will not even say a word about the content. That will be discussed much better than I would do by the panelists. I'll just tell you, I'll be the moderator today, and I'll tell you what we're going to do. Bill will have 25 minutes to present, and then we'll have a panel discussion with the two panelists, one of whom is still missing, but Frédéric will join us soon, hopefully. And we'll have a panel discussion of 15 minutes. And then I want to take at least 40 minutes for you to be able to make comments and ask questions. There are 2 microphones. I will ask you to make 1 short comment or question. You'll have 1 minute maximum. So go directly to the point. And I'll take 3 or 4 at the same time and then ask the panelists to respond so that we can have as many people participating in that discussion as possible in the short time that we have together. So, without further ado, Bill, the floor is yours.
Merci beaucoup, François, et merci, Raymond, pour tous vos efforts dans l'organisation de cet événement. I'm very pleased to be back at McGill University because besides teaching with François for more than a quarter of a century, about a quarter of a century ago, when the legendary John Humphrey stopped teaching his courses on human rights here at McGill University, the dean asked me to come in as a sessional lecturer, as an adjunct professor, to teach one of John's courses here at McGill. And I continue to think how I was touched with this 1 degree of separation with René Cassin and Eleanor Roosevelt and the Universal Declaration of Human Rights. And I guess there are a few people here who studied with John Humphrey or had him as a colleague and remember him with great endearment and respect. I'm today going to talk about this issue of the world, and I think we originally had a title, The Future of Global Justice, or it was even, is there a future for global justice? But there is a question mark at the end of the title, and it's a reflection on what the future may hold in, for international criminal justice. And there's no better way to try and anticipate the future than to look at the past. So I'm going to look at the past a little bit as a way of trying to project what the future may hold. And of course, it's always it's a difficult exercise. I can't remember whether it was Mark Twain or Yogi Berra who said that there's nothing more difficult to predict than the future. the histories of international criminal law generally go back to Nuremberg, and people start by talking about the Nuremberg trial. But in the last year or two, most of my research has been further back than that. I go back just about 100 years ago to what I consider to be the dawn of international criminal justice, and this is the attempts at the end of the First World War in 1918 and 1919 and 1920, so just almost a century ago, to bring to justice war criminals from the First World War, particularly German war criminals, although there was an effort with regard to the Turks as well. And in particular, and this is my real focus, the then Emperor of Germany. He'd been the emperor during the war, Kaiser Wilhelm II. And there's a clause in the Treaty of Versailles that provides for his trial. It never took place because he obtained asylum in a country that today prides itself on being the paradise for international criminal justice. But at the beginning, 100 years ago, the Netherlands was more of a sanctuary for war criminals than it was a place where the beginnings of international criminal justice could be seen. And so the Dutch refused to extradite him or to participate in organizing the trial, and he was never brought to trial. But studying all of that period, we can see the beginnings of debates that remain with us today. Distinctions between the law of the conduct of hostilities, the use in bello, the laws and customs of war, and the law relative to the outbreak of hostilities, the law relating to the use of force, the crime of aggression, and so on. They were quarreling about this and never really resolved it in 1918, 1919, and 1920. They argued about how to attribute responsibility to a head of state who had no direct relationship with the crimes and how to join up the dots so that you could link the Emperor of Germany or an admiral or a general with atrocities that were committed in the field by soldiers at the lowest level. And they argued as well about what a tribunal should look like, how to create an international tribunal. So all of this, it's a fascinating period because it's the beginnings of something that today we know is a very, very developed and robust system of international criminal justice. But it all goes cold in about 1921, and nothing subsequently happens for about a quarter of a century until we get to Nuremberg. So it's kind of like a wave that crests and then dies out. And then at the end of the Second World War, we have a second wave of activity. I mentioned John Humphrey. He was sort of involved peripherally because there was talk about the development of international criminal justice within the UN, within the Commission on Human Rights, of which he was the secretary, and they did work on this. But the main act, of course, after the Second World War was the trial, or the two trials, Nuremberg and Tokyo. And then related developments in the years that follow, the adoption of the Genocide Convention, the adoption of the Geneva Conventions, the work of the International Law Commission and of the General Assembly committees, and then all of that dies out again, just as it did 25 years earlier. And so then we have a second wave. And it's followed by about 20 years where nothing significant happens in international criminal justice. And then it starts to revive in the 1980s with work in the United Nations, in the International Law Commission. And then finally it crystallizes with the creation of the two ad hoc tribunals for Yugoslavia and Rwanda in the early 1990s, the adoption of the Statute of the International Criminal Court in 1998. And we're still in that wave. Whether it's a wave that's going to crest or not is what we don't know. It's kind of like looking at the League of Nations, which is very similar in a way. The League of Nations, which is created in the ashes of Europe in the First World War, and which thrives to some extent during the 1920s and then kind of peters out and dies. And now we have the United Nations. And is that going to happen to the United Nations? It's kind of the same reflection. Will we see a third generation of global organization, or is the United Nations there for good? So we have the modern day system, and it's a very interesting question. It shows no signs of abating, but history tells us that this has moved in waves, and so maybe we're in a wave as well. Part of, I think, the speculation, and I think there's a lot of unease in the field of international criminal law, because there are a lot of people now who are heavily invested in it. There are a lot of people who have made their careers about it and who earn a living doing it. I guess you could say that about me, although, you know, I can still teach bankruptcy law and municipal taxation and stuff. So if it all collapses, I have a few other, you know, arrows in my quiver. But there are a lot of people for whom this is a career. And so, and it may even be one of the factors that's driving the establishment of new mechanisms and new activities in international criminal justice. It's kind of like a wild beast that has to be fed red meat to keep it alive. And so we see new institutions that seem to be of more dubious legal value. I think of the Special Tribunal for Lebanon, which is now in its 4th or 5th year of a trial. Is it about 5 years now it's been going with a trial? It's actually a wonderful trial. You have judges. You have an appeals chamber. They're still doing one trial, only one trial. They have judges with, and then an appeals chamber. They have 5 defendants. They have defense teams for each one of them. They just don't have any defendants. We know that the mastermind of the whole event that the trial is about is dead. And the others may be alive. We don't know where they are. So it's actually, everybody loves it in The Hague because it's a trial without defendants. It's like a moot court, really. It's like the most expensive moot court in history, okay? And I look at that and say, is this thing being driven by the fact that there are lots of people who need employment there in the Hague? So that's another question. We could discuss that a little bit about whether the world is ready for global justice. But let me make an observation about the different institutions we have in this modern generation. The 2 ad hoc tribunals for Yugoslavia and Rwanda, a 3rd institution, the Special Court for Sierra Leone, which is very similar, not identical in terms of its legal construction, but very similar in terms of how it operates to the other 2 tribunals. And all 3 of those have basically finished their work. There's a little bit of winding down now. The doors of the Yugoslavia tribunal have not yet been locked shut, but they will be in December of this year. Someone's going to turn off the lights and lock the door and cancel the lease, you know, for the Yugoslavia tribunal. It's done. And so those 3 institutions really prospered. They did what they were set out to do, largely. They tried the major perpetrators of war crimes and atrocities in those conflicts to which they were related. Hundreds of them. So probably in total, between the 3, 250 to 300 people were charged, and most of them were brought into custody and were tried. Most were convicted, some were acquitted. They did their job. Then we have the International Criminal Court, which was presented as being the institution that was going to replace all of these bodies. They would be the permanent institution, and it now is 14 years into its operations, and it has a budget comparable to that of the most expensive of the temporary tribunals, and it has not convicted or tried 300 people, not even 200 people. It's convicted 4 people. And there's a lot of disappointment about that, and a lot of questioning as to why it's not performing the same way as the other tribunals. Well, the answer probably is complicated. There are probably a number of factors that explain it. It has a more complicated procedural regime that's created by the Rome Statute. There's a lot of other features that are in some ways different, but ultimately it's profoundly similar to the other tribunals. So one thinks, well, what is it? What's the feature of it that's sort of so crucial to the fact that it seems to underperform? And there, if we look at the early debates about setting up the International Criminal Court, I'm talking mainly about the work in a body of the UN called the International Law Commission in the early 1990s, we can see that the International Law Commission envisaged an international criminal court that would be essentially similar to the ad hoc tribunals. It was going to be like the Yugoslavia tribunal, but permanent. And what that meant was that the choice of where it would prosecute, the choice of its targets for prosecution, would not be determined by the court itself, but would essentially be the work of a political body, the Security Council of the United Nations. All of the other tribunals, their targets were chosen by supreme political bodies. Going back to Kaiser Wilhelm, who decides that? The Conference of the four great powers at Paris, the British, the French, the Americans, and the Italians. Nuremberg, who decides that? Well, there's some changes. The Italians are no longer there because they are on the other side in the war. But the British and the French and the Americans are, and they're joined by the Soviets, that's all. And they set up the Nuremberg Tribunal. And then in 1993, when the Yugoslavia Tribunal is set up, and Yugoslavia is selected as a target, why, that's the UN Security Council. China abstains. So it's essentially the same people who were at Nuremberg deciding again on the focus. But the International Criminal Court, although the original thinking of the International Law Commission was that it would be like that it would be the Security Council that would make the determination, the International Criminal Court, the project evolved in the negotiations during the 1990s. The Canadian government played a big role in this. The Canadian diplomats pushed for a different model where the prosecutor of the court would take the decisions about where to prosecute. And if we're looking for the difference between the ICC, the big difference between the International Criminal Court and all the other tribunals, to my way of thinking, that's the central part of it, and that's the central problem, is that instead of asking a political body to make a political choice and then to put its energy behind the prosecution, we leave it to the prosecutor. James Crawford, the Australian law professor who's now a judge at the International Court of Justice, was one of the central players at the International Law Commission. He was the rapporteur on the project, the draft of the Rome Statute, what became the Rome Statute of the International Criminal Court. And if you ask him, I've heard him say this in conferences, you know, why did you have this conservative draft of a statute? Why did they have to change it? Why did it have to evolve? And Crawford himself is a very progressive man. He's not inclined to be conservative, but he said, we gave the world what we thought it was ready for. So what James Crawford thought, and this is our question, you know, he said, the world is ready for global justice, but a global justice like the previous iterations, and one that is dominated by the political agenda of the United Nations Security Council. And he said it changed, and the question is whether the world is ready for that. And I think the answer is still, I don't think it's answered. I think we're still questioning whether the world is ready for that. There are two kind of strands at the International Criminal Court in terms of how it's operated now for the last 13, 14 years. It's had two prosecutors. The first one took office in 2003, finished in 2012. The second, he was quite flamboyant, but ultimately very, very conservative in his choice of targets for prosecution. The second one is a little more modest in manner, but she has been a little bolder in terms of where she has taken the International Criminal Court. The first one is responsible for, first of all, the African focus of the court. He never went anywhere but Central Africa, essentially, and then a couple of places in Northern Africa that were directed by the UN Security Council. And he stayed he stayed clear of anything that was going to risk stepping on the toes of the powerful states in the world. And I don't have time to give all the examples of this, but we have some of them that came up on WikiLeaks, where he reassured American diplomats that although there had been complaints and suggestions that he ought to investigate conduct of the British in Iraq, that they needn't worry, that he wasn't going to go anywhere near Iraq. And whether he'd, formalize that as his policy or not is very clear, that he didn't want anything to do with these zones where he was going to be bumping up against powerful countries. He wanted to stay to, with small countries in Africa where there were problems with civil wars. And that's the other feature of it. He also stayed pretty faithful to the idea that he would go after the rebels and not the government. Now, there are a few exceptions, and in the cases that were referred by the Security Council, he tended to go, of course, there he was directed to go after the leaders, Bashir in Sudan and Gaddafi in Libya. But the other places, he stayed pretty clear of going after the government and went after the rebels. Now, the second prosecutor behaved a little differently, and she has been much, she has still largely confined her prosecutions and her investigations to Africa. She hasn't moved outside Africa in terms of trials that are going on at the court. But she has opened up kind of a new breach, a new front, if you want, at the International Criminal Court through something that is only, it's a phrase in the Rome Statute. It's the end of Article 15 that talks about the prosecutor conducting a preliminary examination. And nobody thought much about it at the Rome Conference. I attended the Rome Conference. The idea was that before the prosecutor could go to judges and ask for permission to prosecute a case, he or she would have to do a little bit of homework. That's all, because you can't show up before the judge and say, I'd like permission to investigate this country. And the judge will say, well, why? And say, well, I haven't looked at the country yet because I'm not allowed to. So you have to do a little preliminary examination. And so that's why those words are there. But it was assumed that this would be a confidential operation, rather like a domestic prosecutor. If you went to the prosecutor here and say, so we know all the people who've been charged because that's all in the newspapers and we can get the files at the courthouse. But who are the gangsters you're thinking of prosecuting? Would you tell us, please? And the prosecutor would say, I'll tell you when we charge them. And so that was the thinking at how the International Criminal Court would work. But some years ago, the new prosecutor, the second prosecutor, started publishing a list of countries under preliminary examination, for which she doesn't need any authorization, judicial authorization. And she also started publishing a report of some 50 or 60 pages every year explaining what she's doing in those countries. And so she revived, about 3 years ago, the investigation into the British in Iraq, the one that the first prosecutor had said he wasn't going to touch. And she went after some others, some of which are listed quite explicitly on the list, like the British it says, Iraq, UK. And the reason she can do that is because the United Kingdom is a state party, so she has jurisdiction over its nationals, even if Iraq is not, and therefore she doesn't have jurisdiction over crimes committed on its territory. But she can prosecute British nationals, and that's what the investigation's about. Then also a few years ago, she put Afghanistan on the list. Afghanistan is a state party. And then in the report, after a year, she started to explain what the investigation consisted of in Afghanistan. And lo and behold, it's not just the Taliban, and it's not just the other domestic forces in Afghanistan, but it includes the United States of America for acts of torture carried out in Afghanistan. And now that's been enlarged in her last report, not only to the allegations, I want to say allegations, I think they're a proven fact in the Feinstein report in the United States of 2 years ago, but she's now expanded that to include also acts of torture that may have been committed in the black sites in Poland, Romania, and Lithuania when the prisoners were being flown and they would stop them off on the way to Guantanamo, torture them a little more, and then take them to Guantanamo. She also is examining Russia. It says Ukraine, doesn't say Russia, but she's obviously looking at the conduct of Russia in Ukraine, and she's looking at Palestine. And it has the word Palestine, but you can guess that involves another country and another army. So in reality, and this is what's so new, she's even moved away from the civil wars that were the obsession of the first prosecutor, the internal conflicts, where he tended to go after the rebels anyway, to conduct of armies in other territories. So it's international, truly international in its dimension, and it involves some of the most powerful armies in the world. And that's quite a radical development. I think it's a very exciting one, and I think the world's ready for that, actually. I really do think the world is ready for that. I remember vividly the enthusiasm at the Rome Conference for the International Criminal Court, and I think it was because people felt that a court, as opposed to a political body like the Human Rights Council, then it was the Commission on Human Rights, or the General Assembly, or the Security Council, would operate in a more objective manner, and that would mean that the countries that were traditionally sheltered because of their importance and their power would finally find themselves exposed as well to scrutiny. And that is what's happening. Now, how much further the prosecutor is going to take it is a question we all ask, and she hasn't yet got to the point of charging anybody or even of seeking authorization to prosecute them from these situations that I've described. But it is a step in that direction, and I think a very exciting one. Let me just conclude with a couple of observations about how the court is working internally. I mentioned that there has been in the past this focus within the International Criminal Court on prosecuting rebels. And that happened with the very first arrest warrants that the prosecutor began. He was working on the situation in Uganda, where the jurisdiction of the court had actually been requested, had been triggered by the president of Uganda, Museveni. And everybody knew, all the human rights reports indicated that not only the rebels, the Lord's Resistance Army, but also Museveni's own forces. I mean, he's not the most charming dictator in Africa, and that his forces were also responsible for atrocities, and that was well documented. But when the prosecutor went for arrest warrants, he only went after the rebels in the Lord's Resistance Army. And he was challenged on this by the NGOs, by Human Rights Watch, by Amnesty International, by academics, saying, why aren't you going after the government forces too? And he said, oh, I'll get to that later. He said, but I'm going after this because I have to respect the notion of gravity. You know, they have a notion, they have this concept at the International Criminal Court of gravity, the law of gravity. And I was telling Raymond, he indulges in excessive flattery of people from time to time. And he put on Facebook, he said that Einstein is going to be talking here at McGill University, and I thought, I'm kind of embarrassed by such a suggestion. But I actually thought about it a little bit. You know, Einstein tried to revise Newton because it was Newton who invented the law of gravity, and Einstein wasn't really very satisfied with the law of gravity, and neither am I. Okay? I'm much more inclined to the relativist view of international criminal justice. So the prosecutor says, it's more serious. The rebels, it's more serious. But it was never very convincing, except that he continued that approach elsewhere, going after the people who were out of power, who were the rebels. And something interesting has happened at the court in recent years as the prosecution has advanced, is that choice of priorities that creates a lack of symmetry in the work of the court, because it's a court that's targeting rebels rather than government forces, has also kind of carried over into how the law is applied and how it's interpreted. So the law, those of you who studied international humanitarian law will know that one of the prime features of international humanitarian law, the law of armed conflict, is that it's supposed to apply to both sides equally. It's a level battlefield where both sides are governed by the same rules. But the judges aren't really applying it in that way, and they're applying it in a way, when they deal with the non-international armed conflicts, in a way that I think treats the rebels differently than it does the government forces. I'll just give one example before I conclude, and that is the recent conviction, about a year ago now, of a man named Al-Mahdi for the destruction of cultural monuments in Timbuktu, in Mali. And this has been celebrated on the internet, on the blogs and everything as a great achievement for the court. I'm not as impressed as some of the enthusiasts for it, because Al-Mahdi was kind of a gift. They just dropped him down in The Hague as a kind of a present for the prosecutor, and said he wants to plead guilty, and he did. And he pleaded guilty, as far as I'm concerned, to the wrong charge. When he went before the judges, they said, but did you have competent legal representation? How would he know? You know, how does an illiterate defendant before a court know whether they had competent legal representation anyway? He answered yes, and the judges were satisfied, and they convicted him, gave him quite a stiff sentence, and that's the end of it. Now, what he did was he led an attack on some cultural monuments in Timbuktu, in a territory that was controlled by the rebels in northern Mali. And they knocked down these historic monuments. And I don't mean to suggest that this was an innocent act or that it was a desirable act, but he did it because there was a decision by the forces that were occupying Mali, occupying northern Mali, for obscure religious reasons to destroy these monuments. It's an inter-Islamic thing. It's one group of Muslims protesting against others, really. And as I say, it probably offends parts of human rights law, but it didn't really seem to be covered by the provision in the Rome Statute, because the provision in the Rome Statute makes it a crime to attack, to intentionally direct an attack on a cultural monument. And this wasn't an attack by any stretch of the imagination. It was in a territory that was controlled. It wasn't a battlefield. And they went to do it with picks and shovels. And I can tell you, in a war, if you want to go on the attack, you need more than picks and shovels these days, you know, to win a war, if you're going to go into a battle. So it's not a battlefield at all, but it's an act that took place in a territory controlled by a regime. Now, they're the rebel regime, okay, but why do I care? You know, if I'm neutral, whether it's the rebels or the government, it's the same thing. So the question is, could the government of Mali, if they were to do the same thing, if they were to destroy a religious monument in Bamako, would that be a crime under the Rome Statute? And I'm sure it wouldn't be. I'm sure it wouldn't be, because they're allowed to destroy buildings. First of all, the provision talks about buildings directed to cultural, religious, what are the other, medical, and so on. It's a long enumeration. If they decided that they thought that the old law faculty up on the hill was a bit of a dump and they wanted to build a new building, if they were to tear it down, they'd be attacking a building dedicated to educational purposes. I mean, it's absurd. Of course, a government can decide that buildings can be demolished at certain times for different reasons. Imagine a Mali, supposing that in this country there had been a civil war 150 years ago, where part of the more conservative forces in the country, who controlled one part of it, were trying to protect the slaveholding regime. And there was another part in the country that was trying to fight the slaveholding regime and to abolish slavery. And the one side wins the war, but the slave owners persist, and they start building monuments to their beloved generals. Just hypothetically, let's call him Robert E. L. Lee, okay, a Mali general, and they build a monument in his honor, and then 50 years later, along comes the government saying, I think that monument ought to be torn down. Well, that's destroying a cultural monument. But I'm not arguing that it's wrong. I mean, I think governments are in a position to take these choices. Now, I'm not trying to get into a whole argument about whether or not we destroy these monuments here. I heard yesterday on the radio coming from the airport that they're going to change the name of Amherst Street in Montreal. I'm all in favor of that too, but I guess there are a few people who were nostalgic for, you know, British Indian killers or French Indian killers here in Quebec. But all of this is to say that that interpretation that makes that a war crime, that it enabled them to convict El Mahdi, is a distortion of the law because they're the rebels, because it's a law that only rebels can commit. They have another case going on about rape of your own soldiers, and once again, I'm convinced that that's a crime that they'll only really charge against the rebels. And so there are these distortions that I think have crept into the law, how the law is applied of the Rome Statute, as well as how the law, as well as the choices the prosecutor makes about the targets for prosecution. I think in the long run, these will jeopardize the court's future. Maybe not, and this is really what the court confronts. It's with us now for a long time. Too much is invested in that court that it's going to die out the way international justice did in 1921 or in 1952, 53, 54. There's a beautiful new building in The Hague that cost 200 million, and as I say, there's a huge industry around this of people who are working. Its real threat is that it becomes a mediocre institution, that it becomes an institution that is confined to one part of the world and going after rebels in one part of the world, and that will disappoint its great enthusiasts. I think it will disappoint global justice in a way, and that problem is not settled yet. That's what the court is confronting, and there are quarrels going on within the court and outside as well about all of this, and I guess I've made it clear where I come down on it, but it is there are people around the court who prefer the more cautious approach, because that way they feel more comfortable to get their pensions when their careers are over, but we'll have a much less dynamic system, and certainly one in this time. I haven't talked about the current crisis, but one that we desperately need. Not only do we need to protect what we've achieved with the court, but we need to make it stronger and more robust so that we can better address the current crisis that confronts our entire planet. Thank you.
Mediocrity is a challenge for all institutions. All of us are confronted with the possibility that we all become mediocre with time. This is certainly not the case of our panel, and Frédéric and Nidal will have 15 minutes to discuss with Bill what's just been said and their ideas about the future of global justice, and then we'll get on to you.
It's hard to disagree with Professor Schabas, and it's harder also. So I know that. Thanks for this. Just to start with one thing, as Professor Schabas mentioned, I mean, I don't want to be the party pooper, but as you know, international criminal law is and remains within a tense, confining a tense internal dynamics with public international law and international relations. It is at a certain moment that international criminal law has made, an international criminal justice project has made considerable leap toward a full-fledged body. And these moments were political moments, were the moment where there was a change in world order, starting 1945, then 1990. And this move to have practically opened the door to have the ad hoc tribunals that contributed a lot, despite being criticized as being also selective justice for one country and one situation rather than the others. But with the idea, again, opening the door of a new change in world order and probably more a liberal, we were presuming a liberal world order, this opened the door to idealists and people like believers in the international justice project that it will pass and be able to overcome the political equations and the political balance of power in the world. This happened with the ICC itself as an idea, moving from an ad hoc, fragmented international criminal project to the idea of having a treaty-based, universal international criminal court. So practically, as if we thought, and the observers thought, that we are moving from this reactive, fragmented, incomplete body of law, justice, to a more unified, unitary body that supersedes traditional terms and norms of international law, meaning state sovereignty, the idea of withering of the state, idea of rule of law above international relations and international politics. This momentum with the ICC, unfortunately, after that, lost its brightness when it was the Security Council again continued to play a role as a law-making body, ad hocly, retroactively, and incompletely. This is precisely what happened, for instance, for the Special Tribunal for Lebanon, where in reality, you used in terms of procedural law and international criminal law, for one ordinary crime, using all type of legislative creativity to achieve a suitable political outcome. And in reality, the problem, Professor Schabas, is not only there are no accused arrested. The problem further is that the STL lost the political momentum. So it was built for that political momentum, and the political momentum is over. But at the same time, there are damages to probably the international criminal justice project, indirectly or directly. Although there are few contributions, I know the late Professor Cassese wanted an international definition for terrorism. I hope it will be, and I hope February 16, 2011 decision can, although it has its shortages and criticism for that. But there were other costs, other negative costs for what we witnessed after that. In terms of, again, Security Council played a role on that, but at the same time, we won an ICC. We won an ICC that existed, and we hope that it will remain existing despite the change in political balance of power. Because sometimes you win at a certain moment a progressive steps in terms of this international criminal justice project, but you cannot guarantee that the world is progressive to move in the same direction. September 11 and the after showed us that we may lose what we won, and it's not something guaranteed. So ICC itself, as Professor Schabas mentioned, is not perfect. In fact, it suffers from a lot of weaknesses and shortages. I don't want to weaken your belief in the court, because we all believe in the court, but I want to highlight them so that it could be important to shed light on that, so that the ICC can improve, can be strengthened in an international system now that is not very much favorable to the human rights movement and to international criminal justice project. So the weaknesses, I would talk first, statutory weakness is a very weak cooperation system. The ICC depends on a horizontal cooperation system, not on a vertical cooperation system, although this is in theory, because even the ad hoc tribunal who enjoyed primacy, they still suffered from cooperation problems. And the former Yugoslavia and other states cooperated with the ICTY for reasons that are not purely related to the legal or for the statute of the court, but rather to issues related to entering to the EU and pressures at different levels. The other issue to talk about is, again, the crime of aggression, which entered into the statute. And this is not a weakness, this is a blessing in some point. But I'm afraid it becomes a curse. Is it too early for an embryonic court that does not enjoy that much of power to be able to hold and to delve into an issue at the core of public international law and the Security Council prerogative and states' sovereignties? We are seeing that it is still struggling with a Security Council referral, where we presume that states will abide in Darfur, in Sudan, and in Libya, and still nothing is moving forward on that. On the policy level and the practical level, also the ICC showed some shortages and some narrow-sightedness, I would like to say. One of them is the state referrals. The state referrals, as you know, the ICC statutes allow states to refer situations to the court. Although Article 17 and other articles do not prevent state referrals to be admissible, and this is what the former prosecutor called uncontested admissibility. The long term or the larger picture in terms of the outcome of such a process, I think, is devastating and is negative for the court, because it allowed able and willing states to use the court a la carte when needed for their own political and probably economic and local motivations. Again, example again is Uganda. Uganda is a system that is functional and it's willing. It's only a matter of custody, and look at Ongwen now. Why the reason Ongwen went to The Hague? Ongwen should go to Uganda, as simple as it gets. The LRA fugitive was arrested. So I think this also damaged the image of the court in front of the wider public opinion. The wider public opinion is not only a Hague-centered or New York-centered. It is places of people who really, the simple people who do not know the ICC, but believe in a certain type of justice, and they are trying to judge through the practices and the policies of the ICC, not going to the technicalities of the work of the ICC and what is in and out of the statute. The other point I want to highlight is that although the ICC is a court, the ICC is at the end of the day also an international organization. And this is a blessing and could be a curse at the same time. It is a blessing because also the ICC is interacting through the complementarity mechanism with domestic systems to try to help the natural judge, probably, indirectly, or sometimes even directly, to be able to take the primary responsibility to prosecute international crimes and strengthen the rule of law. It's too far-fetched, too ambitious, but it's worth the shot. It's worth a little bit of attempt and try. But at the same time, the interaction with domestic systems, with cooperation with states, with different situations, not only one situation, entails that the ICC not only have the best legal experts, and the ICC does have the best, very good legal experts, but it needs much more knowledge in situation, in the dynamics of change, in the dynamics and the political interactions of the systems locally and regionally. This proved to be very weak at the ICC. Having a degree from Harvard that is not enough for you to understand countries in Africa or Middle East or the Far East. It can be, but it's not enough. It has other elements that are needed. This is the experience we witnessed in Libya. In Libya, there was a lack of knowledge of what is a system in transition, although the system collapsed. So now it's a dead debate, but I'm talking about the early days of the interim government and how much the Libyans were proud that they want to prosecute at the beginning, at the early beginning. They were not given this shot. And the mentality was, give us the big fish and take the smaller fish. This is not what the complementarity was about. So in the same vein, there is a weakness in the outreach of the ICC to reach to the other part of the world, and rather the ICC probably, and the policymakers in the ICC are more focused, Hague-oriented, New York-oriented, and I would say probably maybe stuck into this bubble that needs to be broken and getting out. Although now the political momentum is not at its best moment. So to conclude quickly, ICC is a need to the world and is more a need to the human rights movement and to us, especially in the time when there is a retreat on this movement, at least to maintain what we have, but also to improve it into a more respect to rule of law and a stronger international criminal justice system. Thank you.
Hello. First, apologies for arriving late, and second, I'm mindful that the clock is running. I think we will probably want to open to the audience very quickly. So, Nidal, you've covered a lot of ground, so I won't repeat your points. I think there's one thing I wanted to pick on, which I think is interesting, was when you said we all believe in international criminal justice, and I think that's a very general statement, and I suppose, you know, there's something to the idea that beliefs about international criminal justice sort of constitute it. If we remember, I had a professor in my first year of international law at the Sorbonne who used to say international law must exist because there's people who get paid to practice it, and there's sort of, you know, ministries of foreign affairs, and so that's a kind of brick and mortar theory of the reality of institutions. I mean, I think it could exist in that way, but not exist in any significant political sense at the same time. I think you know, is the world ready for global justice question is a fascinating one. It's an old one. I mean, this was the question in Versailles, and this was the question in the 1950s. If you reread the debates of the International Law Commission, it's always like, you know, it's kind of Zeitgeist question. You know, is it too early? You know, and of course it was too early at the time because of the Cold War. So there's a sense in which you're always trying to get the institutions right for the time. Now, that may be difficult if you believe strongly in international criminal justice and the kind of absolute need to punish certain crimes, because you might be unwilling to make certain concessions to just, you know, to concessions to the reality of the world as it is in the current context. And also I think there's an extent to which, you know, it's not that simple. It's not simply that, you know, we kind of look at the world and then devise institutions that are right for the moment. Is we hope that in kind of releasing institutions into the world, they will produce their own reality and they will construct a world where their presence is acceptable and natural, right? So, I mean, I think you don't want to get it completely off if the world has to be kind of ready, but I think the last 100 meters have to be, you know, accomplished by the institution itself, and that's based on its success. So on that, I think just in terms of measuring the success of the ICC, I think you know, it was never meant to try many cases. It could have tried a little more than it has. But I think there's a, you know, there's a question there about the narrative. Is this a history of institutions? When we have a multiplication of international tribunals, that can't be a bad thing, but it's not everything. We can have a lot of international criminal tribunals and very little international criminal justice. Is it a history of trials? Well, probably trials count for a little more than just the existence of a tribunals, but then probably we need to, if we're fair, we need to compute all of the domestic international crimes trials that have occurred maybe in the last decade, and maybe, just maybe, would not have occurred had it not been for the kind of looming presence of the International Criminal Court. So on a kind of scorecard, I would, you know, but that at least partly to the credit of institutions of international criminal justice. And then there's another narrative, which is a legacy of legal innovations, right? So even if a court doesn't prosecute many people, there are procedural innovations, there are innovations in terms of a role and status of victims, in terms of reparations, in terms of the definition of substantive crimes. As we've seen, some of them, you know, are clearly wrong or could be improved, but that is part of a distillation of international criminal law, how it gets received. So I think we need to have a look at the broader picture and not be too focused on the kind of institutional destiny of the International Criminal Court. There's maybe one or two other things I wanted to mention. First, when Raymond initially circulated the title, I thought, you know, well, global justice, you know, so are we going to be talking about, you know, global right to migration and, you know, income redistribution, etc. And of course, and understandably, Bill, you only meant it in a kind of narrow sense of international criminal justice. Now, that's quite interesting, right? If we said, if a question had been, is Canada ready for justice? And the presentation had only been on, you know, how well the criminal justice system is doing, well, everyone would say, well, you know, yeah, I mean, that's just a very small part of the overall justice equation. You know, it's important, but so internationally, of course, you know, there's a sense in which criminal justice, international criminal justice, become very dominant in the institutionalized definition of justice. We also have the International Court of Justice, which does something different. But I think it might be useful to think a little more in terms of a relationship of international criminal justice to these big global justice issues, the complementarity. You know, I often think, for example, the relationship of international criminal justice to interstate justice or human rights justice is a little under-conceptualized. Lawyers wrote a lot of articles on litis pendens issues, you know, very between the ICJ and the ICTY. Now that's interesting, you know, who's more authoritative, etc. But if you're thinking about this more in a strategic way, you might think, well, you know, we need to have these multi-pronged strategies, right? So if we're dealing with former Yugoslavia, we need to have a truth and reconciliation. In Bosnia, we need to have international prosecutions, domestic hybrid prosecutions. We need to have Bosnia suing, you know, Serbia and Croatia, and we need, you know, all kinds of other constitutional institutional reforms. And so I think understanding international criminal justice as a sort of complex piece of these moving parts is important. And then maybe just a final point on the kind of endlessly sort of vexing question of a relationship to the political. I think the deep ambition of a lot of international lawyers has always been to emancipate international law from the political, right? To kind of once and for all cut off the umbilical cord, and for, you know, international lawyers to exercise their own rule, one that is distinct from and presumably above from the political. And, you know, this is, in the case of the International Criminal Court, this is complex. So getting rid of politics is understood as getting rid of these outside, sort of presumably toxic political influences, such as the Security Council, etc. The Security Council, you know, is legal, it is a creature of international law, but, you know, it's seen as, I think rightly, as very political, and to increasingly transfer power to judges, independent and impartial prosecutors. Now, I understand that as a sort of classical liberal move. At the same time, it constitutes these prosecutors as at least hyper-decisive actors, right, that need to make what would otherwise be seen as incredibly political decisions about who gets prosecuted or not on the basis of highly discretionary criteria that, you know, sooner or later we'll have people asking the question, well, why should the ICC prosecutor be deciding, over fortunes of entire countries, factions, etc.? And so I think rather than thinking of this as a sort of emancipation of politics, I'm not sure what that means, but international law and politics are imbricated. It's more a question of what kind of international criminal, justice policy, if you kind of more comfortable with a policy term than politics we want. And here I think, Bill, your presentation is very enlightening for me on this topic. There's different schools, there's different strategies. I think the overall strategy of a prosecutor has been a kind of politics of safeguarding the institution and maybe reifying the institution as opposed to what it's supposed to deliver. And so the path is sort of let's reassure everyone first. And I suppose, maybe there's a hidden plan to kind of sneak up on them after a while and say, now that you've entrusted us with the destinies of international criminal justice and, for 10 years, we've only prosecuted minor sort of guerrilla leaders, etc. We're finally going to sort of speak justice to power, right? And so now, of course, there's always a possibility that that moment never comes, right? And then we just kind of settle in this endless mediocrity. And I think there's a deep reflex in people who are institutionally minded to, the judges and prosecutors are entrusted with the institution as well, right? And of course, they're working for it, so they have a certain interest in its survival. I think there's a case that an institution like the ICC should, occasionally really sort of fight the fight and speak truth to power and maybe sort of go down in flames if that's what it takes. But that's a very perilous decision to make. But I definitely agree with you that the gravity is in the eyes of the beholder, right? So the body count criterion of gravity, the idea that, there's a lot more victims in the Congo than, people who were tortured in Abu Ghraib, well, it kind of just, to me, doesn't work, right? It completely fails to appreciate the degree to which justice is a function of who the actor is, the context, relations of power, etc. I'll leave it to that, and maybe Bill can address some of those, and we can hear more from the audience.
Since we don't have that much time, I'd like to give what's left to most of you. So if you want to line up behind the microphones, and I'll take a number of interventions, please make your question or comment short, 1 minute maximum for the panel, and we'll take a series of comments and questions, and then we'll ask the panelists to thank you for breaking the ice. Go ahead, Tanya.
So I just wanted to thank the panel for what was a really fun event, to sort of post-mortem. And I wanted to ask Professor Schabas about your post-mortem specifically on Ocampo's tenure, because on Ocampo's tenure as the prosecutor. And one of the reasons that I had this question was that, I was in the Middle East when he was going around doing his goodwill tours, trying to get support behind the ICC. And I remember him, it was distinctly, you got the feeling that there was a certain precarity that he was dealing with. So I'm not surprised that when WikiLeaks came out and there was this idea that he was making deals with the United States. So my question is, how was your solution any different if you said that the idea, it would have been better had it been the Security Council who was already making the decisions of what was going to be prosecuted? How would this be any different than the kinds of political calculations that Ocampo made? But it goes to kind of a secondary, deeper question, which was Nidal and both Fred talked about it in terms of the idea of criminal justice. Why is it on the international level the same kinds of political calculations and the kinds of capturing of the criminal justice system by the powerful elites should be any different from what we see on the domestic level? I mean, in some senses, it's the same kinds of structures that are being reproduced on the international level, but we somehow feel like the political alliances change, that you're progressive if you're for the ICC on the international level, but you're progressive if you're really a public defender in the domestic. And so it's just this question of, is the institution really much different?
Thank you. Yes, go ahead.
My name is Tanya as well. I have actually two questions. One is for Professor Schabas, and one is for Nidal. And my first question is this. So you mentioned that there has been this progress in that the political elites are playing a weaker role. So my question is this. So what were the processes that enabled the prosecutor to have a stronger voice? And what lessons can we take for the human rights struggle in general? Because, as you know, as Tanya mentioned, the political elites do dominate the field, and there is also a question of funding, that human rights organizations do depend on funding, and that individuals who have more funds tend to have more power. They also have their agendas, and they are also shaping what kind of work human rights advocates can do. And my second question for Nidal is, you mentioned that it will be very valuable for these international mechanisms to take into account the local dynamics. So could you please elaborate on your idea and explain precisely the way, what would need to happen, and the precise mechanism, and what kind of dynamics would need to be taken into account, and how, as well as what impact will be achieved through the changes that you propose. Thank you.
Thank you very much. I go back to that microphone over there. Go ahead.
Thank you very much.
Panelists, please take notes, because there will be a number of questions and comments.
Thank you very much. My name is Kims Banda. I come from Zambia. My question goes to Professor Schabas. I would like to know, in your view, to what extent the ICC is threatened by the by the court to withdraw by member states from the court. I have in mind that I think early this year, the African Union passed a resolution calling for mass withdrawals from the court. And I would also want to find out whether there are any concrete steps that the court is taking to address these cause. Thank you.
Thank you. Going back to this microphone.
Hi, Camille Lustière. Thank you. First, I just wanted to ask, do you think that, drawing on the notion of gravity, is the world ready for taking on better steps against the sexual and gender-based violence in international court in general?
Great question. I'll take this microphone now.
I wanted to just ask all the panelists, like in a country like Afghanistan, I'm asking because my parents are from there and families from there. There's so much cynicism over this idea of global justice because of the fact that during all the international intervention, there's just been like, everyone's hands are so dirty, and so, you know, everyone on every side has been so involved in abuses, including Canada, USA, not just like, you know, our personnel, but like the people we work with. Like everyone, the people that we're promoting in government, for example, have been responsible for the massacres of like thousands, like tens of thousands of civilians on the ground, and you know, they're put up in positions of power, propped by us. And then on the other side, you have people who are equally guilty, being, you know, prosecuted for crimes that all sides have done. So how do you maintain any sense of like legitimacy, local ownership, just like, how do you just kind of, I don't know, maintain any legitimacy for the idea of global justice in a context like Afghanistan, where the only difference of who's being prosecuted and not is like who your political, you know, friends are, who's been helping us there, but where, you know, everyone's been torturing and killing and massacring, and it doesn't seem like there's much, yeah.
Thank you. Last question for this round. Yes, go ahead.
Hi, thanks to all of you for your insights. So I have two questions here, and then the first question comes back to what Camille just pointed out. And so I wanted to touch upon a little bit about gender justice. Actually, what brought me here in this panel today, I saw in a poster in the hall, and then it was written, "Is the world ready for gender justice and not global justice?" Yeah. And then I thought, well, just looking at the poster, we see that we all have male panelists here. I'm not saying anything, but is this something that reflects the actual world? And then the second question goes to Professor Mégret. So you also mentioned that this talk was predominantly about international criminal justice, and then we didn't really talk about other forms of justice. So I would be interested in knowing, in your opinion, what would be other forms of justice that should be prioritized in this context. Thank you.
Thank you. Gender point well taken. Panelists, you have, let's give you 2 minutes each to make initial comments on the points that you've just heard, and then we'll try to get some more comments and questions in. So who do we start with? Bill?
I didn't select the panelists, so don't blame me for that part. I was invited to give a talk, and then they constructed the panel around me. I had breakfast with François this morning and spent some time trying to entertain him with stories about Kaiser Wilhelm in the World War I. What I didn't tell you, François, is that I came across documents in the British and the American and the French archives of applications or petitions that were sent to the Paris Peace Conference by women's organizations demanding that if they prosecute war criminals at the end of the First World War, that they make sure not to overlook the sexual, and they didn't use the term sexual and gender-based violence. They talked about rape and enforced prosecution, which was the term that they were using at the time. But it's all there. I've been telling it. I found it absolutely fascinating. And when I tell it to some of the lawyers who've worked on these crimes at the international tribunals, I say, you thought this began in 1993, actually, but it actually started in 1919. And by the way, it's the only evidence I found in all the files of any campaigning for prosecutions. It was women's groups. It was the height of the suffragist movement, and that was going on. So in 2 minutes, I've probably already used up the time, but I can't answer all the questions. But I do want to say, and it follows from something that Fred said, it is a political environment. It's a political environment, and personally, I think that's why I like it, actually. I like the fact that we're dealing partly with law and partly with politics. My problem always is that I find that I don't always like the politics of the people who are running the system. So that's my problem with the first prosecutor, Luis Moreno Ocampo. He had, I think, other shortcomings, actually. I don't want to get into a long analysis of his complex personality, but he didn't probably help the court that they picked him as the first prosecutor. But the problem that the court has had with the prosecutor has to take these decisions that are inherently political. That's the magic of the court, if you want. It's not that the prosecutor becomes some neutral, apolitical entity who replaces what previously was always a political body. But the prosecutor is supposed to follow different logic and to be attuned to different features of it. If the Security Council, I mean, the thing, if we ask, why doesn't the Security Council act on certain things? Why doesn't it go against the British in Iraq? We know the answer. It's built into the Charter of the United Nations. There's a veto. Why doesn't the Human Rights Council go after certain things? Well, we know there's a political dynamic there. But the prosecutor doesn't have that. The prosecutor is freed, in theory, from all of that. Now, what's interesting is when they come, the job description of the prosecutor. Historically, the prosecutors were people with political antennae. Robert Jackson at Nuremberg, Richard Goldstone at the International Criminal Tribunals, followed by Louise Arbour. They were people, none of those three would qualify to be the prosecutor at the ICC, because the job description now at the ICC is experienced international prosecutor. And so you get people who are, without wanting to be disrespectful of them because they're fine people, but they're technicians. They're the people you hire as your assistant to do it. And when they were hiring the last prosecutor, when Fatou Bensouda was chosen as prosecutor, they had a search committee. They had applications. There were more than 50 people who sent their CVs. But we didn't see on the short list the people like Louise Arbour or Richard Goldstone or Robert Jackson. Instead, we saw people who'd sort of worked, arisen through the system, and they were good prosecutors, very good at it. They have skills that, the political people don't have. But when Richard Goldstone or Louise Arbour or Robert Jackson needed people to tell them how to do the actual technicalities of the prosecution, well, they hired talented people who did that for them. And so that's the job description, and we don't take that into account. We live with this It's a myth. But when we select the prosecutor for the court, we live with this myth that somehow we're finding someone who's an apolitical person. But they're not. We just don't know what their politics is. And it turns out that Luis Moreno Ocampo had, shall we say, a penchant. He had a leaning towards the United States. Just simple as that. Fatou Bensouda seems to be more independent of that, but what exactly her political views are, I don't know. But she has them like all of us do, really. You know, I do an exercise with students sometimes when I'm teaching this, and I give them all a piece of paper, and I say, imagine that you're the prosecutor at the ICC, and you, in theory, can exercise jurisdiction over any crisis in the world. Only one. You only get one pick, because your resources are limited. Put down on the paper where you would go, okay? And I get, usually there's a flavor of the month. So today it'd be either Syria or North Korea, I suppose, or maybe Myanmar today. This week, we'd get, you know, a bump for the Myanmar people, okay? Whereas 2 months ago, no one would have heard of Myanmar, you know? Sometimes we get Sri Lanka. It depends what's in the headlines. And then there's always kind of an undercurrent. There's always a lot for Palestine and North Korea and so on. But they're kind of political choices we make ourselves as individuals, and the prosecutor does that. And it's I think ultimately it's a weakness, it's a flaw in the system of the ICC, because to detach the ICC from political control of the Security Council or something resembling it, the idea was, we'll go all the way and we'll have the independent prosecutor who's subject to, you know, for whom it's essentially an individual personal decision, one person. And with no oversight and no mechanism for scrutiny or anything like that, not even re-election, because they're only allowed to have one term. And I think probably it's a flaw in the system that will have to be addressed at some point, not by bringing back the Security Council, not by creating something resembling it, but doing something to enhance the credibility of what is ultimately a politicized decision by the prosecutor about where to go. And we don't have the answer to that right now.
Yeah. To answer the question on what do I mean in terms of local dynamics, not to exaggerate things, I think many people would agree that if not for complementarity, probably the ICC as a compromise would not have existed. This was the workable formula that states accepted to move on in a system, again, we're still living in a system of voluntarism, states would have accepted. But at the same time, I'm calling to that complementarity is not being read only as an element in terms of jurisdictional division of labor or organizing jurisdictional relation with the court. I'm saying that the court needs to be more in-depth understanding of its position vis-a-vis states and vis-a-vis systems, especially in countries where there is a possibility for change. There is a possibility to combat and prosecute those core crimes that are of interest of the ICC. Therefore, probably more focus in terms of the situation, analysis of at the situation level, to see if this country is moving or is willing and able, then the argument should be different than if this country is unwilling. And then based on that, not to adopt a very narrow competitive process with domestic systems, although they want to do it. So again, you challenge admissibility, and the court adopted that the challenge is true at the earliest moment, but at the same time it said, only I take evidence at the initiation of the challenge of admissibility. So it is confined to that. But in situation of transition, where sometimes the state is willing and is rebuilding its institutions under a transitional justice process, maybe 1 month, 2 months, you'll have a structure, or at least doing something. Do you wait a bit, or no, you say, sorry, tough luck, time is over, I can't, I have to do it this way. What is your philosophy behind that? Why are you closing the door for those who want to do it and want to do it properly or trying? Probably you can help them or somebody, but what is the point to take more cases? Why are you putting yourself in the position of competing for show trials rather than being a court, as you said earlier, that is, the success of the ICC will not be measured by the number of cases it prosecutes, but rather by the opposite way forward.
2 minutes. So very briefly on whether the composition of this panel is reflective of the state of international criminal justice, I would certainly hope not. And in fact, the International Criminal Court was the first tribunal to have mandatory gender representation, and although international criminal justice has come a long way from, the Tokyo Tribunal that, did nothing about forced prostitution in Korea, it did a lot in the 1990s in the former Yugoslavia in relation to Rwanda, tremendous pressure to make sure that prosecutions took into account sexual violence, and I think the ICC is doing much better. In fact, I think it's become central to the mandate of the court and the current prosecutor. So there's hope there. On what other type of justice, I just mentioned that international criminal justice has become a bit dominant and hegemonic in terms of our responses to societies in transition. The paradigm used to be broader. In the early 90s, people were speaking of transitional justice more broadly. The totality of the justice issues arising from transitions, and all kinds of truth commissions and vetting and constitutional reform, etc. And then criminal justice tended to kind of absorb everything or sort of become equated with transitional justice. And I think there's something to be said for, recovering the globality of the agenda. And finally, maybe briefly on Tanya's point, do we have any reason to think that international criminal justice will not reproduce many of the dead ends and of domestic criminal justice? Well, no. In fact, I think there's a real research agenda waiting, bringing to bear some of the critical studies of criminal justice domestically to the international level to show that, issues, for example, of structural racism, etc., plague international criminal justice in visible and invisible ways just as much as they do domestic criminal justice.
Thank you very much. Bill, I wanted to give you the last word of wisdom.
Well, we had a question about Africa from Mr. Banda, right, from Zambia. The 3 countries withdrew from the International Criminal Court late last year. 2 of them have reversed that, actually, and so the outcome is not clear, but what looked like it might gain a lot of momentum and do a lot of harm to the court has not happened. It seems to have slowed down, and I guess that time will tell on it. But I think that, it was to be feared, the call from the African Union, but it doesn't seem to have been followed. It's probably met with a lot of enthusiasm from the African states that haven't ratified the Rome Statute, but the ones that have are very hesitant to withdraw. And so right now there's only one, Burundi, which, if you know about what's going on in Burundi, you can hardly blame them for wanting to withdraw from the court, because they are likely to be a target for prosecution.
Thank you very much. I think we can thank Bill, Nidal, and Fred for the very inspiring moment that we've had here today. Thank you, Bill, for coming to McGill. It really was a pleasure to have you with us. And thank you to all for being here.